So you're watching this video because you want to learn about Secretary of State hearings. More specifically, you probably want to get your driver's license back. I understand exactly how difficult it is to go through life without a driver's license. So we take this topic very, very seriously, and that's the point of this video, or really this whole series of videos, and it is to arm you with the knowledge and really the technique and the procedure for you to go back to the Illinois Secretary of State and have a successful hearing and get your driver's license. So in this video, we're actually going to answer the top 7 questions that people have. Think of this as an overview of Illinois Secretary of State hearings. So we're going to talk first about what is a Secretary of State hearing. Number 2 is, do you specifically need a hearing, or is there sort of another way for you to get your license back? When are you eligible to actually go to the Illinois Secretary of State and have a hearing? And the next question, the 4th section, is going to be about what are the different types of hearings, because they're not all the same. Some are easier than others. Some you may be eligible to go have, some you may not. Next is the timeline of a hearing. It's not an overnight process. So what does that timeline look like? What are the possible outcomes to the hearing? So you have the hearing, you get an answer. What can those answers be? And finally, what actually happens at that hearing? Really important thing to know, obviously, if you're going to walk into the Secretary of State office. So by the end of this video, of course, you should have a great understanding of exactly what you need to do to have a successful hearing at the Secretary of State. And then it'll be up to you to go ahead and nail that hearing. Now, one bit of warning. Our office has done hundreds, maybe thousands of Secretary of State hearings over the years, and I will tell you, they are not easy. It is possible for you to do this yourself. It is not required that you have a lawyer. But realistically speaking, the vast majority, at least of the people we see, of course, had a lawyer to take them through this process. And that is something we do. I think probably generally speaking, you're going to wind up with a better outcome with a lawyer. But I realize not everybody wants to do that. Not everybody can afford to do that. So the purpose of this video is to give you everything we know, get you as close as I possibly can to being able to do this yourself. So what is a Secretary of State hearing? Well, it's a process here in Illinois through the Illinois Secretary of State that you have to go through in order to get your license back if it is revoked. So let's talk about that, because first off, there are people with a suspended license and there are people with a revoked license. Suspension is for a defined period of time. You may be suspended for 3 months, 6 months, 12 months, 3 years. But regardless, it is a defined period of time. And at the end of that, you will get your license back. Now, you have to pay a reinstatement fee. But at the end of that suspension, you get your license back, provided you've done the things you have to do. That is much different than having a revocation or being revoked. That means your license is gone. It's not automatically coming back at any given point in time. In fact, the burden is on you to go back, petition the Secretary of State, have a successful hearing, and get your license back. So it is very costly to not take action. In other words, if you do nothing, if you never have that hearing, when your license is revoked, you will never get your license. Do you actually need a Secretary of State hearing? Well, that all starts by getting your Illinois driving abstract. It's called a court purposes abstract, and you can get that. Sometimes you can get that online through the Secretary of State, or one surefire way is to go into any DMV location and get your own driving record. Then you have to read that record. You have to go through it and see what's on there. See what the things on there are causing you to be revoked. Most commonly, that is a DUI conviction. Now, that's what happens, is if you get convicted of a DUI anywhere while you have an Illinois license, your license is very likely to get revoked. So obviously they learn about Illinois DUIs, but these days they even learn about DUIs in other states. You see, there's this interstate compact where most of the secretaries of state in each state in the United States communicates with each other. The computer systems send information back and forth. So if you have an Illinois license and you get a DUI in Wisconsin, Iowa, Ohio, Florida, California, anywhere in the United States, it's very likely that the outcome of that DUI case will be reported back to Illinois. And if that's a conviction, Illinois is going to say, you were convicted of a DUI somewhere, your license is gone. You are revoked. And that's the most common reason that people need a hearing. Now, you have to get that abstract. You go through the cases that are causing the revocation. In very rare circumstances, you can actually go back and fix that case. It's rare, but it's absolutely worth looking into. If you can fix that underlying case that's causing the revocation, then you may be able to remove the revocation without having a hearing. Again, it's rare because most of the time you stood in court and you pled guilty and you really only have 30 days to take that back, and those 30 days have long passed in many cases. But sometimes there are some tricks to the trade where a lawyer can reopen that case and remove it from your driving abstract. In all other circumstances, you're going to need a hearing with the Secretary of State. All right, so a really important question is, when are you actually eligible to go have a hearing? Because the Secretary of State won't see it anytime. You have to be eligible for a hearing. So there's really 4 important factors that are going to determine whether or not you're eligible for a hearing. Number 1 is, do you have any open pending cases? Number 2 is, how many DUIs have you had? And number 3, how much time has passed since that last DUI? Really, what is the timing of all those DUIs? That really matters. And number 4 is, what are the changes that you've actually made in your life, right? Lifestyle changes, sobriety, length of sobriety. Those things are all really going to matter in terms of whether or not you can have a hearing, or really whether or not the hearing will be successful. So let's go through those just a bit. So if you have an open pending traffic case, you cannot have a hearing. Secretary of State wants you to have all those done and closed out before you can come to them and ask for relief, ask for a license. This is significant because many people who are revoked continue to drive, right? I get it. I understand why, but the way the world works is you're going to catch another case eventually. And when you do, you're no longer eligible for a hearing. So all your cases have to be closed out. Next thing you want to look at is how many DUIs do you have? How many DUI convictions do you have specifically? Because 1 DUI is obviously going to be a whole lot easier than 4, for example, right? So let me give you sort of the rule of thumb on these. There are some nuance, but I'm going to give you a nice overview here. Number 1 is, if you have just 1 DUI, how much time has passed? Because you can go to the Secretary of State right away and have a hearing, but for 1 year after that DUI, the best you can get is a restricted driving permit. After a year has passed, you may be eligible to get a full reinstatement of your driver's license. If you have 2 DUI convictions, generally speaking, then 5 years has to have elapsed since the last DUI. Now, again, you can go to them and have a hearing right away, but the best you can get is a restricted driving permit within those first 5 years. After the 5 years, you're eligible for a full reinstatement. 3 DUIs is a 10-year holding period. So again, get the 3rd DUI conviction, you can go have the hearing, but at best, you're just going to get a restricted permit for specific reasons, driving to work, medical appointments, things like that. That may be great. That may be life-changing for you, but you should know what the eligible sort of relief is. After those 10 years have passed since your 3rd DUI conviction, you then become eligible at least for a full reinstatement of your driver's license. Now, for DUIs is where it gets a bit tricky. Just keep it simple by saying that technically there's a lifetime ban on you getting a full reinstatement of your driver's license. But you may be able to get a restricted driving permit, and that may be amazing for you. That may allow you to drive to work, which is many people's goal when they're revoked. So really depends how many DUIs you have, and then also, like I said, how much time has elapsed since then. So the fourth thing is a practical application of are you really going to have a successful hearing, right? You may be eligible on paper to go have the hearing, but is it going to be successful? And some of the factors we look at there is, have you implemented any lifestyle changes since those DUIs? You may be required to show a period of sobriety. So how can you show that, right? Have you done your treatment? Do you have a history of attending AA classes or some sort of counseling, right? Those are the things that in many cases need to be demonstrated at this hearing. So even if you're eligible, but you haven't done those things, you're probably not going to have a successful hearing. So that's where, this becomes part art, right? In knowing, really how successful you're going to be at a hearing, because there's no point in going to have it if you're just going to get denied. You want to have a fair shot. And so that's where these lifestyle and sobriety things come into play. So to summarize, big 4 pieces of information to determine if you're eligible. Do you have any open cases? How many DUI convictions do you have ever, anywhere, in any state? Number 3 is how much time has passed since that DUI or that most recent DUI? And finally is sort of practically speaking, can you demonstrate the things that are necessary in order to have a successful hearing? Or do you need a little bit of time to maybe get those things in order first? All right, so now we know what a hearing is. We know that you need to have one, and we even know that you are eligible to go have a hearing. So the next question is, what type of hearing should you have? There is informal hearings, formal hearings, and out-of-state hearings. Let's go through each of those. So an informal hearing is, well, like it sounds, it is far more informal than a formal hearing. And so this is a hearing where you can sort of walk into almost any DMV location and have a hearing. Now, you need to have done some prep work ahead of time. You must have an evaluation and some things, but you can walk in, sit down with the hearing officer, and have a hearing. Now, that's it. That's how informal it is. Now, you're not going to get an answer right then and there. That answer is going to come later in the mail, but you can just go have that hearing. Again, it's not going to do you any darn good. In fact, it can do some bad. It can set you back if you just go have that hearing while you're unprepared. But that is what an informal hearing is. And you should have an informal hearing, or you can have an informal hearing, if you have just one alcohol-related offense, one DUI, nothing else, no other DUIs, no drug-related offenses, right, that are going to show up on your abstract, no open alcohol tickets, just one alcohol-related offense, then you may want to go have an informal hearing. In the other circumstances, you're getting bumped up to a formal hearing. So 2 alcohol-related offenses. Most commonly, it's 2 DUIs or more is going to result in needing a formal hearing, and that is much more formal. You have to request this. You have to pay for this ahead of time. You have to schedule it. You have a specific date, time, and location for your formal hearing. And they don't just do them anywhere. There's only 4 locations in Illinois where the Secretary of State will do a formal hearing. That is Chicago or Joliet. That's where we typically do them, at one of those locations. There's also Springfield and then Mount Vernon, which is in southern Illinois. And like I said, it's far more formal. It's recorded. You are under oath. There is your attorney, if that's the route you decide to go. There is a hearing officer, and there is an attorney, or kind of think of him like a prosecutor, kind of, from the Secretary of State. So you 4 people are in a room, and it is a full question and answer hearing And that will determine whether or not you get that license back. That's probably the one that occurs the most, just because it's 2, 3, 4 DUIs. That's the one you need. And finally, there's an out-of-state hearing. So I mentioned earlier in this video that there's this interstate compact, right, where all these secretaries of state talk. So one common scenario is somebody gets a DUI while they have an Illinois license, and there's a revocation or a hold put on them, right? Then they move to another state, Florida, Tennessee, California, doesn't matter. And then they go get a license or try to go get a license in their new state. Well, that new state is going to look in the interstate compact. They're going to look in the database and see that Illinois has placed a hold. And that new state is not going to give you a license. Or even if they do, they may catch it eventually and not allow you to renew your license. So now you got no choice. You don't have a license in your new state. You have no choice but to go back through Illinois and try to get them to release that hold. That's an out-of-state hearing. And that doesn't require you necessarily to be here in person in Illinois. You can do that through the mail and a series of forms. That's an out-of-state hearing. It's the least common, but really important, especially if you no longer live here in Illinois. So there you go, 3 types of hearings: informal, formal, and out-of-state hearings. Gave you the brief rundown on exactly which one you may need to have. Next, let's talk about the timeline of this whole process, because it is not quick. We have people all the time call us and say, hey, I need to get my license back next week, right? It's not happening. In fact, I'd say on average, it's about a 6-month process. The longer you wait, the longer it's going to be until you get that license. So let me give you kind of the steps that we go through whenever we represent somebody. And that is, number 1, determine if they're eligible. That is huge and almost half the battle, right? Because we talked about all these different types of hearings and scenarios and background. All that has to be pulled together to first determine, are you eligible to even have that hearing? And if so, when and where and how? That's really, really important. In fact, we have a whole report that we put together for our clients who have engaged us to do that for them. Next is the evaluation and documentation. You're going to need an updated drug and alcohol evaluation. That evaluation must be within 6 months of the hearing. So you have the evaluation, and then within the next 6 months, you've got to go have that hearing. So there's some timing there, right? And that evaluation can be good, it can be favorable, it can be not so favorable. It can uncover some new things. It can add some additional requirements. You're going to have to show the treatment that you've completed, right? So that evaluation is really, really important. And let me tell you, just like lawyers, just like everything else in life, there's some really good evaluators and there's some not so good. I've seen some amazing detailed reports that just give our clients such a leg up in that hearing. I've also seen some ones that are just not good work, right? No detailed explanations, short one-word answers in terms of that evaluation. And it's really, really hard to go have a successful hearing with a bad evaluation. You're only as good as the documentation and the paperwork that you bring into that hearing. So again, really, really important part of that to nail that down. We're going to talk about that more in some future videos. Next is, once you've gotten that evaluation and you or your attorney have gone over it all and realized, hey, I've got everything here, I am ready to go have this hearing, well, then you're going to request it. You're going to request that hearing. Specifically, if it's a formal hearing, you have to go ahead and request it. If it's informal, you don't. You can just walk in. But before you do, you're going to want to prep for it. We know exactly what questions get asked at a hearing. In fact, we're the ones that ask our clients the questions. We're the ones that get to direct or control the hearing when we represent somebody. But even if you're doing it yourself, you still are going to have to answer those questions. And so we're going to give you exactly what questions are going to be asked in your hearing. We're going to do that in a future video. But you need to practice, right? You know the questions, you know the answers because it's in your documentation. You have to be prepared for it. You have to prep for a hearing. This is just like being back in school. You got to memorize, you got to practice, you got to prep for it because this is such a big deal. Finally, is you got to go conduct the hearing. I already kind of gave you a little glimpse into what that's like. Some people bring a lawyer, some people choose to do it themselves, but you have to go do that hearing and you have to nail it because the Secretary of State can deny you. And they will deny you for many, many reasons. It is a tough burden to meet. It is difficult by design to get your license back after you've been revoked. And so once you've had that hearing, the only thing left to do is wait and see what the answer is. Typically, you're going to get that answer within 90 days. It's usually about 6 weeks, but they can take as long as 90 days to give you an answer. And so that's where I came up with the 6 months, right? Even if you were ready today, you'd have to go get the evaluation. That could take a couple weeks. You would have to request the hearing. That may be a month or 2 months out. And then you go have the hearing. You don't get an answer for another 3 months. So on average, it can be as long as 6 months before you even get an answer. So the timeline is a long one, but it is important to understand that before you engage in this process. So that brings us to what are the possible outcomes of a hearing? Well, there's really only 3 things that are going to come out of it. You can either be denied outright and get nothing, get no relief. You can be, if you are eligible, you can get a full reinstatement of your driver's license, right? Here you go, here's your license. That's the best possible outcome. But very commonly, something in the middle occurs, and that is what's called a restricted driving permit. Now, you have to show a hardship, you have to be eligible for this, and you have to be granted it, right? It's not automatic. But if you get a restricted driving permit, there are some restrictions. You can only drive at certain times, at certain places, and you may oftentimes, almost certainly, need a breathalyzer device in your car. But that is still a very good outcome for the vast majority of people because that restricted driving permit, now you may have to renew it for a number of times, but eventually, if you do everything right, that is the stepping stone to getting a full reinstatement of your driver's license. So one of those 3 things will happen. Not much to talk about if you get a full reinstatement. It's amazing. If you get a restricted driving permit, well, then there's some things you're going to have to do, and we can go through that. And really, the Secretary of State tells you exactly what needs to be done and what those restrictions are. Now, if you get a denial, obviously you're not very happy. Nobody wants to go through all this work and get a denial. But I'm going to give you a little bit of silver lining. When they give you a denial, the Secretary of State tells you exactly why. It is written out in big paragraph form telling you exactly why you were denied. And so while that's not the outcome you want, you are one step closer to having a successful hearing. Because what you need to do is you need to go back, do a lot of these steps again, and go have another hearing. And that hearing needs to be better than the last one. And you have the benefit of knowing exactly why you were denied last time. You can address that and have a successful hearing. So it's not uncommon for people to be denied. Like I've said, I'm warning you, it is a very difficult process. People do get denied. But again, I want to sort of reassure you that you still are one step closer. So inaction is the absolute worst thing you can do, is just say, oh, well, I don't have a license, I'm not going to do anything about it. You're never getting one then. Even a denial is better than inaction. So I want to spend just a little more time here on talking about exactly what happens at a hearing, because if you haven't been through it, well, that's what's on your mind, I think, right? And I touched on pieces here, but I want to paint the picture for you. So an informal hearing is you and the hearing officer. And if you choose to bring an attorney, well, then your attorney as well, just 3 people. And it's not recorded, right? It's not necessarily, being recorded where every word is being. Instead, it's sort of a question and answer format where the hearing officer is writing down your answers. It is far less formal. But most people have a formal hearing. And that is audio recorded. There is not only the hearing officer there, but there's sort of a prosecutor, an attorney from the Secretary of State there. And they may cross-examine you, right? They may trip you up, right? And so it is a far more formal process. But in that scenario, there's 3 or 4 people. The hearing officer, the attorney from the Secretary of State, you and your attorney if you choose to have one. Again, you are under oath. Anything you say can be a basis for a denial. Any of the paperwork that you bring in, if it's not sufficient, that can and will be a basis for denial. And the final part I want to stress to you is that you will spend probably at least an hour testifying related to what happened on your past DUIs, what your pattern of typically alcohol consumption has been throughout the years, what it is now, how long you've been sober, what you've learned from treatment, any lifestyle changes, family situations, things that triggered your alcohol or drug consumption. There's a lot to talk about, and you will get asked those questions at a hearing, and you will be testifying under oath to those things. And it has to match with your paperwork. It has to match with what your treatment says. It has to match with what your evaluation says. So there's a lot of hoops to jump through. And again, this is by design. The Secretary of State does not want to make it easy for you to get your license. They want people to get their license back, people who have legitimately changed their habits and their lifestyle and who are no longer a danger or no longer a threat to having a DUI on the road. But they don't want to make it easy on anybody. You now know exactly how that works, but that is just scratching the surface, guys. This goes way, way deeper than that. We have so many more things to talk about. So thank you for watching this. I hope you've now got a good understanding and you're excited to jump into the next steps of getting your driver's license.